And here we go. The case kicks off with Juan Sanchez at the center of the storm. But this isn't just a routine hearing watched closely, because what starts as a simple motion to compel quickly spirals into a clash of legal strategy and courtroom tension. Real courtroom drama at its finest.
All right, this is cause number 1830854, and sir, you're Juan Sanchez. And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena duces tecum was the proper way to try to get information. Duces tecum is an order that somebody brings them into a set hearing. So if we didn't have a set hearing, they weren't ordered to give it to it at a set time for a hearing. So under the rules that have to do with subpoena duces tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things probation have in their file and that's just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it, to make that request, is to discover. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is really not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think that's too far along. But lab results, testing, money owed, all those types of things, I think probably discoverable and something that we should need. I just don't think this was the
judge change call. We think it's discoverable. Case, it's all allegations on the motion is not arrested in the county. So it's a finished record on it. I don't know what's in the probation file. It's not even part of that. Motion I responded.
Well, let him finish it.
It's enough Warren County records, so some probation and the name for this and well, even all that stuff. A lot of it's not information. So I have county office support and things like that. I don't have this for the doing like but yeah, not I don't count all this stuff.
Sure.
So and this thing is make and discover request the onset involvement to our information.
Right.
I don't have it.
Here's a quick breakdown. A subpoena duces tecum isn't just a fancy Latin phrase. It literally means bring it with you. It's used to force someone to bring documents to a set hearing. But since no hearing was scheduled, the defense attorney's move here, technically off the mark. Legal procedure matters, folks.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discovered?
Your Honor, my client is going to sit on probation. The court will take rate on the file. His court and everything else. As part of determining the motion to revoke is relevant to look at on the file on probation, particularly if you request to stay on. He's been on probation nearly 6 years. I think over 5.5 years, nearly 6 years. And that performance is being helpful in determining or mitigating whether he stays on probation or if the court decides he goes off of probation, and perhaps mitigating his sentence.
Okay, I don't disagree. So, again, though, I think the way to do it would be to make that request I mean, and I don't know what conversations y'all had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The duces tecum is not the way to do it unless it's set for hearing. That's just rules of evidence. So that's not the way we're going to do it.
The duces tecum was sent for the day she sent for a hearing, and it doesn't fire not to. We ended up moving the hearing. Didn't call. That asked.
Yeah. I mean, yeah. I don't think on this list that there are. I mean, is there anything that y'all we had an issue with? If there's.
Boom, this is where the judge drops the big question. Why are you asking for stuff that's not even part of the allegations? Now, put yourself in the defense attorney's shoes. Would you push back for more evidence? Or play it safe and stick to what's on the motion? What would you do?
Your Honor, this gives you a clarification of and my chronological would include anything that pertains to the case that happens with chrono telephone calls, auto-generated appointment, reminder, office visit, blood test, anything to be generated as other chronological information, as well as releasing from jail law, subpoena verification. In all our reports, those were not listed on the subpoena, as well as the offense report through the GM. So, to clarify that to those items typically being released that were not into the
Your Honor, we don't have to do things. It's all 3914. So let's get this bill. This things because we didn't get any of the information related to probation in our 3914. I would also note that chronological.
Well, and these aren't. The reason you didn't get any of those is because those aren't his. They're theirs. So they're not. I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, if y'all get together, obviously offense report. If y'all have the offense report and you don't even have it, then you need to get that's great. Everybody can get the information in a minimal way. So let's do that. Y'all sit down. I want everything that you have that is. I don't know that there's anything I can think of that would be.
I guess
not,
my notes maybe one part.
That's what I'm thinking about, but it's not really attorney's notes, and I don't know that that would be an issue.
Without Your Honor, it's not a product. It's really work product. It's really discoverable and relevant.
That's what I just said. You seem very frustrated, and I'm not sure why. I don't know.
I'm confused why there's pushback at all. And even for us to work 3914 discovery when it's constitutionally allowed to file. It's used by probation validated. You got to get a letter just for the adjudicating introduction of discovery. They had to file a motion to compel.
Well,
that is a long.
Listen to this laundry list of records drug tests, office visits, phone calls, even interlock reports. Probation leaves a paper trail for everything. And here's the kicker. These details can make or break a defendant's chances at staying on probation. One missed test, one bad report, it could all come back to haunt you.
To me, that we have to tell anything else 3914.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on. And the last thing you want to do is talk over me. So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do, because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial, of what you've discovered, that it goes through that portal. Everybody knows what everybody's got. So y'all get it to Mr. Nichols. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? It exists. And he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in a couple weeks or so. Fine with that?
Whoa, did you catch that? The judge is actually on the attorney's side, but the lawyer can't stop arguing. And in court, tone matters as much as facts. A judge doesn't like being talked over, and here, the lawyer risks sinking his own case by being combative. Sometimes less is more.
Okay. Perfect. Thank you. All right, y'all are with you. Sorry? No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date. Enter pleas of not true or true to certain allegations. Then we'll reset it for a court date. And at that point, if you need to be here, let us know. If you need a subpoena, then you can get a subpoena. If you need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good? All right. Thank you, y'all.
And just like that, the judge lays down order discovery through the portal. No shortcuts, no backdoor fights. Case reset for later. This may look procedural, but behind the scenes, it's a battle of access, strategy, and control. Stick around, because next time, when those files finally surface, the real fight begins.